In 2003, MGM Metro-Goldwyn-Mayer Incorporated filed a suit against Grokster Limited for copyright infringement. Grokster was an internet company that allowed people to use the internet to share stored digital information such as music, movies, books, etc. from one user to another user, also known as peer-to-peer file sharing. Copyright infringement is a crime that violates another's intellectual property rights such as copyrights, patents, and trademarks. The suit went to the United States District Court in the state of California. The decision of the suit was in favor of Grokster and was dismissed. This was due to the copyright infringement case Sony versus Universal City Studios, in which the decision was to dismiss the case due to the use of the VCR videocassette recorder. Users of the VCR recorded shows so they could watch it later, and the VCR manufacturer would not be responsible for what the users of the VCR did with it. The case, MGM versus Grokster, was filed by MGM to the United States Court of Appeals for the Ninth Circuit. In the appeal, MGM argued extensively that Grokster's inducement was to use advertising or solicitation to entice Napster's former users to use Grokster's services. Groksters also did not do anything to filter any of their content, so there would not be any infringing activity. And lastly, Grokster made money by selling advertising space to entice more and more customers to use their site. Quote, the inducement theory requires evidence of actual infringement by recipients of the device, the software in this case. There is evidence of such an infringement on a gigantic scale, end quote. Therefore, the United States Supreme Court held Grokster to be held liable for copyright infringement of the peer-to-peer file sharing on Grokster's networking sites.
This evidence alone, the three presented features, would not justify an inference of unlawful intent. One who distributes a device with the object of promoting its use to infringe copyright as shown by clear expression or other affirmative steps taken to foster infringement, going beyond mere distribution with knowledge of third-party action, is liable for the resultant acts of infringement by third parties using the device regardless of the device's lawful uses. And although the Copyright Act does not expressly render anyone liable for another's infringement, on Sony 464 US AT 434, these secondary liability doctrines emerge from common law principles and are well established in the law.
The rule on inducement of infringement is developed in the early cases is not different today. Evidence of active steps taken to encourage direct infringement, such as advertising an infringed use or instructing how to engage in an infringing use, shows an affirmative intent that the product be used to infringe, and overcomes the law's reluctance to find liability when a defendant merely sells a commercial product suitable for some lawful use, a rule that premises liability on purposeful, culpable expression and conduct does nothing to compromise legitimate commerce or discourage innovation having a lawful promise.
Okay, so the outcome of the case is that the court decided in favor of MGM. This is due to the fact that not only was MGM able to bring up evidence of intent to bring about infringement and distribution of a device suitable for infringing use, it also had evidence of actual infringement by recipients of the device or the software. And so, as you can see on the slide, one of the three main evidence it brought of intent to bring about infringement or distribution is that neither respondent attempted to develop filtering tools or other mechanisms to diminish the infringing activity using their software. Basically, they made no effort to stop anyone from using their software to infringe. And second of all, that software was used quite a bit to infringe and copy stuff from MGM and a number of other companies. So there you go.
Today, I'm gonna share the gospel principle for the case of MGM and Grokster. The gospel principle that I've learned is about honesty. Grokster was liable for copyright infringement. They cheat by facilitating the copyright to gain revenue on the advertisement. I took the quotes of Margin Ashton from Liaona, March 1984. It stated, "Honesty is a way of life. It is not an announcement, a declaration. It is a virtue that we achieve step by step." As we know, as a member of the church, we believe in being honest. To be honest means to be sincere, truthful, without deceiving at all time. Being honest means as well, don't lie, don't steal, don't cheat. So, we know that we lose the guidance of the Holy Ghost if we are dishonest. We might find that we have damaged relationship with family members and friends and other people as well.